All right, good morning. We're on the record in the matter of Gregory Martin, 24PR00777. Time and place set for a continuation of a trial that on August 27th. We'll start by having the parties place their appearances on the record with the petitioner.
Good morning, Your Honor. Megan Salisbury here on behalf of Petitioner Gazelle Fuller.
Good morning.
Your Honor, Samantha Bungie, same.
Good morning, Your Honor. Nathan Rudolph, bar number 124419. I am the court-appointed attorney for the respondent, Gregory Martin Sr.
Good morning.
Good morning, Honorable Judge Riedel. This is Ross Takei Waleed, a.k.a. Greg Jr., interested person.
Good morning, Mr. Waleed.
Good morning, Your Honor. Selena Wilkes.
Good morning, Ms. Wilkes. Okay, so let me just set the table here. Where we left off last time, Ms. Garvin was being cross-examined by Mr. Waleed. So that's where we'll eventually start. Ms. Garvin, I recall you also had a trial assignment today.
Tomorrow.
That's tomorrow. Okay, so we're okay today with your schedule. Okay. If you're going to be a witness in this case, or you think you might be a witness in this case, I'm going to ask that you wait in the hall. We do that because when you testify, I don't want you to be influenced by other things you may hear in the courtroom. So if you are going to be a witness, or you think you might be a witness, now's the time to be in the hall. If you're sitting in the courtroom, you're not going to be able to be a witness.
Stay or go until I'm called.
If you could wait in the hall, Ms. Garvin, thank you. All right. That said, we intended to, and will proceed with some preliminary matters. One could call them pretrial matters, I suppose. The good news is this is a bench trial, and so there's some flexibility with these issues. So as I recall, Mr. Waleed had filed a motion. It was a little unclear to the court exactly what you were asking, Mr. Waleed, and we'll get to that in a second, but it had something to do with the court taking judicial notice of something. And so, and we started that conversation last time, so we're going to kind of revisit that issue, and I'll start with Ms. Salisbury. If you could give the court your position on that issue.
Good morning, Your Honor. So I reviewed the status letter that was filed by Mr. Waleed, and I do believe, and I can't find it, there are a few things in here that I believe are not relevant for the purpose of judicial notice.
Can you do me a favor, Ms. Salisbury? There are quite a few filings in this rather new case, and so what date are you looking at?
So the status report was filed, well, actually, I guess it was emailed to us. Actually, I don't know if it was filed, but it was emailed. I do not have a filed date on here. I'm just an emailed copy. The motion for judicial notice was filed on August 8th at 1:04 p.m.
Okay, let me scroll to that one. Sometimes the labeling
No problem.
by ours case processing folks labels things different than maybe what is intended. So you said August 8th?
Yes, August 8th of this year at 1:04 p.m.
I have located a declaration filed August 8th, 2024 at 1:04 p.m. By you, Mr. Waleed. And that declaration is in support of your motion and brief for judicial notice. I believe we're all looking at the same thing. There were several exhibits also filed along with that motion. So, all right, I think we're all in the same ballpark now. Ms. Salisbury, go ahead.
Thank you, Eric. So I don't object to Chapter 125, the court taking judicial notice on that, as it is the statute with regard to protective proceedings. However, the remaining portions of it are not relevant. There's a request for probate code. Probate code is not applicable in this type of proceeding. There's a request for Chapter 63 about limited liability companies. I don't see how that's relevant. There's a chapter regarding Oregon administrative rules for employer and insured coverage responsibilities. Again, we are now dealing with a workers' comp issue, so that's also irrelevant. As well as, looks like volume 16 for the trade practices in ORS, title 51 of the labor employment, and then again chapter 656 of workers' comp, as well as some specific statutes listed in there. Again, we're not dealing with a workers' comp issue, so I find that to be irrelevant. And then there's part of the Constitution regarding privileges and immunities and due process, equal protection, and all those kind of things. I don't find any of it to be particularly relevant beyond Chapter 125. I will say, and it's not listed in here, but ORS 127.002 through 127.045 is the statute with regard to powers of attorney. And I would find that to be relevant. It's not requested in here, but the court certainly could take judicial notice of that statute, as well as I believe powers of attorney are important in this particular matter. So I object to everything that's not 125 or 127, or that's 125, 127.
Okay, thank you, Ms. Salisbury. All right, Mr. Waleed, my understanding of this motion is that you are requesting the court to take judicial notice of various areas of the law.
Yes.
Am I saying that right?
Yes, correct.
Okay, go ahead.
According to the law, the court is advised by the Oregon Supreme Court to take judicial notice of statutes, of constitutions. The constitutions, things that she talked about as far as reference to this particular case here, is the 14th Amendment lack of due process that was not granted to me or my father with respect to our contractual agreement as being durable power of attorney. We had on the stand as a witness giving testimony last week, which was Megan Huffman, the Department of Adult and Protective Service, who did mention that she did not contact me, which was a part of the law, when I was the one that contacted her, gave her notice of my durable power of attorney. That is the reference to that. Oregon does not have a due process clause in its constitution, and the 14th Amendment protects my rights of due process, that I was supposed to be contacted and given an opportunity to administer my durable power of attorney rights to my father, which he had required or requested that we do that. The other statutes that deals with the corporations, as far as this particular Oregon advocates approached the court on April the 18th, and they were not licensed to do business in the state of Oregon. They were supposed to wind down. That means just closing out, not come to petition to the court for new business in that particular application, nor did they tell the court that they were out of business when they amended that. So it's something that was kept in secret, and these judicial notices are all the rules that affect the business if they're going to petition for my father's business over our $10 million estate. I think they should be, every other business has to abide by the rules of the Secretary of State, and being revoked, not just for one day, for 8 months before they file their petition into the court, for the record. That is a negative as far as the Secretary of State, and this court should be, as far as anyone approaching, not commencing a defense of winding down the business, like protecting themselves from a lawsuit. They came to the court under fraudulent misrepresentation and filed a petition to the court knowing that they were out of business. That's what the judicial notice. The one about the workers' comp is they mentioned themselves in the petition, initial petition, emergency petition, to the court, asking the court to waive 2-day notices, etc. So those who are part of the people in 125.060 of protective proceedings, we're supposed to be notified. And there was a lot of waiving of 2-day notices, etc. Just those things that relate to 125. Everything on that judicial notice is something that is honorable to bring to the court to take notice. They don't know our testimony, what we're about to give notice to, so they would be an objection. It would seem like who would object to any state statute or rule or constitution of the United States or Oregon in this particular matter?
Okay, Mr. Willey, I think I could help you out here. The court is going to take judicial notice of the law. A motion is not needed to file that, but I understand that you're not an attorney and you might not necessarily know that, so you're covering your bases. And so over Ms. Salisbury's objection, I'm going to consider any law that may be relevant to the issues at hand in this case. It may be that some of these things you've mentioned are not relevant. I don't know. I haven't heard the whole case, but I will be taking judicial notice and considering any law that, again, is relevant to the issues at hand. So I think that takes care of that motion. Ms. Salisbury, anything left on that motion?
No, Your Honor.
All right, Mr. Willey, anything left on that motion?
No, I have another one we talked about.
Okay. And then, yeah, I want to make sure that the goal is to get through any other motions that we have. So, Mr. Willey, you had another one.
Yes, I wrote a status report to the court and filed it yesterday. And that status report talked about the 5 motions as well as the appeals that was not maybe on record, but the Oregon Appeals Court granted us access to the database yesterday, knowing that my father's case is a protected hearing, so it's not on the public display. You had to get special access to be able to get to that. We had to get special access in order to get to my father's case, but it was filed and received on August the 23rd, 4 days before our court hearing. And I have a case number I can read into the record for that. It's relevant with respect to, we had special hearings, contested hearings that were ex parte, that according to local rules were not supposed to be heard by the court because we have a particular judge already assigned, which were you. I believe we were waiting for you to be sworn in. However, this was a July 29th hearing that I was supposed to be given 24-hour notice of the hearing according to the local rules, and I was not given that. And this has been a part of the precedent that the legal counsel for Oregon Advocates has been using throughout the case. And in the order signed by Judge Alarcon, she made notice that this particular hearing or this protective order that they requested was supposed to be sent within 2 business days to all opposing parties. We never received that. She was told about that in the hearing and in the order. And so that particular issue as far as the appeals is important because of that specific matter. There were some violations that we are going to connect to, several of non-notice of, we never got notice. Neither we get notice prior to the 24 hours to tell us that, hey, I'm going into ex parte. And then the ex parte was not supposed to be ex parte because this is a contested hearing. So there's obviously professional rules of professional negligence on making sure we got it, as well as approaching the court with a contested hearing that's not allowed in ex parte. So I'd like to talk about the appeals being talked about, or at least allowed into this hearing, because it's very valid with respect to what we're doing.
Okay, thank you, Mr. Martin, or Mr. Willey. I have some questions for you.
Sure.
You said you filed a motion yesterday.
Well, it was a status report to the court.
Okay.
Just updating it so that way it wouldn't have been left off.
And is that what's labeled? There are several filings on the 3rd and the 4th.
Yes, and some of them are just exhibits.
Some are exhibits.
And then one is the claim that I'd like to talk about when we get to the motion of the petition for personal representative. We had 1, 2, 3, 4, and including the court mentioned that it was a conflict of interest, and we found out through the Oregon State Bar claims against the state and family, which was a seminar that was given by an attorney here that stated that it is not a conflict of interest for me as a secured party to have a claim against my father as being a personal representative. However, I have to submit the claim to the court, not through myself.
Okay, so I want to just make sure I understand what the motion is. We last time talked about you requesting to be a personal representative, which
Correct.
I consider to be a counterclaim in this matter. We addressed that issue because to be appointed a personal representative would require, correct me if I'm wrong, Ms. Salisbury, your dad to be deceased for that issue to even be relevant. And is that Ms. Salisbury, is that correct?
That is correct, Your Honor.
Okay, so personal representatives don't get appointed for persons who are still living.
Okay.
So that's why
Okay.
we're not doing that. Does that make
Yeah,
sense?
it was not told clear as to what the statement was. We just knew everyone jumped on the
Now,
bandwagon.
I know they are arguing is that to the extent that you're requesting you be appointed to be the indefinite fiduciary for your father versus Ms. Fuller or versus Ms. Wilkes, they're arguing that you wouldn't be a suitable person under the law because there's a conflict of interest. I don't have any findings about that. That's just their argument, and that's what we're doing in trial. So I think that we're on the same page on that issue, that's their argument, and then you're going to put on your argument.
Thank you.
Okay.
Thank you.
All right. So does that handle that issue?
That
Mr. Lee?
handles that issue. Yes, it does.
Okay. Are there any other pending motions that we need to deal with?
Yes, and this was the motion for to terminate that was filed with the court. There was a motion to terminate guardian and conservatorship because for lack of notice, according to ORS 125.060 and 125.065 for the petitioner's counsel, and they haven't received notice. They were supposed to do certain things, and that ties into the appeals process where Salisbury approached the court, and I think Bungie was both there. They were supposed to give us 24-hour notice. This is a contested case. They did not do that.
Okay. So you had filed a motion.
Yes.
I try to make sure I'm hearing you, so I'm just going to repeat back to what I understand that you're telling me, which is you filed a motion stating, my words, hey, when they got the temporary guardianship, they didn't give me the 2 days notice, and that is not appropriate under the law. Am I saying it right so far?
That, as well as all other processes in that. They have never done that part.
The process, okay, and
Yes.
all other
And not just me.
processes with respect to
give a
how
notice.
the temporary guardianship came about.
Yes.
Okay, now my understanding is that that particular issue is what you have filed an appeal for, correct?
No. The notice of motion and brief to terminate the emergency guardianship was filed August the 1st into the court. With the motion, everyone was served by it, and it stated several different things. Lack of notice, ORS 125, standing or locus. They didn't have any standing. They were not legitimate business when they filed that petition with the court. Neither were associated. And then they had the clean hands doctrine was mentioned in reference to all that. There were some issues that weren't taken care of, and there was some side biting or kicking, talking about what we were doing with my father, taking him out of hospitals, and Contractors Information Bureau agents showing up to see my father. It's mentioned in these petitions, which we had Jessica on stand. She said she didn't say it. We want to know where did that come from, because it's in the petition like I'm really showing up to the court, or my agents, and we're in Montana. Our agency is in Montana. We work all over the country, but we're in Montana. We established ourselves here in 2000 with Contractors Information Bureau, Oregon Division. We moved and became national in 2013, so we moved to Montana 6 years prior to that. So, but this particular motion to terminate is what this really, we believe, started this hearing, because we were seeing things that were happening that were not according to law as far as notice.
So
we just want to make sure that was brought up, because this motion wasn't mentioned in our pretrial, and maybe because of my fault, maybe not filing it or bringing it to your attention that day. We just went through a review with our counsel, and there's some other things happening on the federal level, so we just wanted to make sure that this got into the record and to be fair to the court, so that way you could disperse justice correctly.
All right, thank you, Mr. Lee. So I do see your motion that I believe you're referring to, filed August 1st at 2:03 in the morning, entitled Notice of Motion and Brief to Terminate Emergency Guardianship and Conservatorship for Lack of Notice, Standing, et cetera, et cetera. That's what you're referring to,
yes,
correct? Okay. To the extent this is not an issue that's up on appeal, I'll take it up. But Ms. Salisbury, your response.
Yes, Your Honor. So I believe what we're here talking about today includes that motion. Obviously, the reason that we initially were here was because multiple objections were filed to the emergency petition for temporary, and then as well as the regular petition for permanent guardianship and conservatorship for Mr. Martin Sr. And then this being filed, arguably this is the time and hearing for any of those kind of motions to be heard. I don't believe this would qualify as a pre-trial motion or anything like that. I also would like to point out, if in a review of this case, all of the required notices have gone out. We have not missed any of those, and if the court didn't believe that waiver of notice for an emergency situation was necessary, they wouldn't have granted us the waiver.
Objection.
We would have had an opportunity. At that point, they would have said, no, you need to give notice, and we would have given the notice prior to the hearing. So that was definitely a decision the court had made. There have been multiple emergency situations, just to kind of fill you in. We had the original emergency hearing for the appointment so that Mr. Martin Sr. would have someone to be able to make medical and financial decisions, which resulted in the removal of Miss Celine Wilkes and Earl Wisdom as having any role as a power of attorney. Those are only good for 30 days, a temporary order. So we got there was an extension that was executed by Judge Henry for a continuation of that order. And then because you're under the statute under 125, you're given one extension for the maximum of 60 days. At that point, we did, with Judge Alicon, have a hearing regarding an emergency temporary protective order that would continue until the permanent hearing on this matter had been concluded and a decision had been made by the court with regard to whether or not a permanent guardianship and conservatorship was needed, who that person was going to be. So those are the things that were presented, and the waiver, the request for that waiver was considered by the court at that time. And then in the statute, it does state that when you do a waiver, you have to give notice within 48 hours after the signing of the order. And so those were then issued within that time frame out to all of the known interested parties at that time.
Okay.
So,
Thank you.
so I think we're here hearing that today, that amended notice and motion and brief to terminate the emergency guardianship and conservatorship.
So it's your position that this is an issue that is wrapped into what we're doing in the trial?
Yes, Your Honor.
Okay, Mr. Rudolph.
Your Honor, this is the time and place for the court to make a determination on the appointment of the indefinite guardian conservator. Therefore, the temporary will expire upon your ruling with what happens with the hearing today. So I agree that this is exactly what we're doing here in this hearing.
Okay. Mr. Lead, any last comments on that?
Thank you. This particular case has been very frustrating with respect to the family of the respondent, who has over 27 people, 7 children. 2 of them were only notified. I was the beginning one who made the initial Adult Protective Services report in December on my father. Everyone, as far as the court reporter, court visitor, the Adult Protective Services, and even the council, they have all failed my family and failed the court and the Oregon statutes on giving notice. They cannot prove they sent anything, but we know that because it was not sent. We had to go contact the records department and pull and pay for all the files to get them certified, so that way we had information what was happening. And you'll probably hear today in some other testimony of others as well as mine who just weren't receiving any notice. And because I'm in Montana, and because I'm the one that made that, it was in their, maybe their limited interest to not notify me, so that I was always behind. So I just want to let the court know that when we talk about a lot of filings, when someone's rights are being violated and their due process and their 14th Amendment Constitution is being violated, expect some type of fight back, some type of response back, because you're not doing the rule. And to make notice to that particular termination of guardianship, this particular group, whether the court or anyone else could see, they approached the court under fraudulent misrepresentation, stating that they were a legitimate business, legitimate in filing this petition for emergency protective order.
Okay,
and they
Mr.
weren't.
Lee, thank you for the additional comments. What I'm hearing from you is that you wish to argue why the guardianship maybe shouldn't have been issued in the first place, but in any event, here we are. It was issued, and why it should not continue. That's the issue for the hearing today. So with respect to your motion filed August 1st at 2:03 in the morning that I previously referenced, I do agree with Ms. Selsbrand that that is an issue that you're going to be arguing during your case, and you have been arguing during your time in cross-examination here. So it's not an issue that I need to decide before we begin today.
Okay.
It's something that you'll be making an argument about throughout the case, as you have been. All right, so that takes care of that motion.
Yes.
Are there any other motions, Mr. Willie, that you believe need to be heard before we begin?
Yes, it was the motion on the motion for a new court visitor. The court.
Okay, I do recall that you made a motion last court hearing I think it's the same one. You made a motion that the court appoint a new court visitor, correct?
Yes.
And the court ruled on that motion, and I denied that motion.
Well,
so that's done.
My question is, as far as the status report, this court visitor filed another report, which makes it 2 reports. One is separate from the other. One says that the advocates are...
Yeah, I understand, Mr. Willie.
Okay.
She filed a report back when the case started in April. She filed an updated report just before we were in court last time.
The day before court, yes.
You have both of those reports.
Yes, I do. Yes, I do.
We heard that motion last time. You requested via a motion that I appoint a new court visitor. I denied that motion. So that's done.
Well, we had filed another motion in response to the second report. The first one was about the first report. Our status report updated.
Okay, what's the motion with respect to the second report?
The second report is that, like the first report, the court visitor made statements that I could not protect my father from the issues that were happening as far as any financial exploitation, et cetera, et cetera. And so she mentioned that she was in receipt of all of these different court filings. She commented on them. She said different various things. And then she said that the Gazelle guardianship was
Ms.
troublesome.
Ms. Fuller.
Yeah, Ms. Fuller said Mrs. Fuller guardianship was troublesome. and then we watched her in front of everyone change her mind, say some different things, then came with, I'm in support of.
Okay, so what I'm hearing from you, Mr. Walid, is you reviewed the report and you think that her report is inaccurate. That is consistent with my ruling last time, which is I've denied your motion to appoint a new court visitor. However, you are welcome to, and I know you have been already, during the course of your case, to put on evidence as to why the court should discredit the court visitor's report and recommendation to the court. That's what you're doing. And so I think that issue is handled.
Well, can I add one thing?
Sure.
In this second report, like the first report, she made statements that were hearsay. And as we're conducting, someone offered her to be a professional witness that has done over 4,500 reports and cannot recall the statute or what defines the report, 125.070, which is the report. And as a professional, because I didn't really hear, did we finish that? Did we?
Well, you're continuing your cross-examination, but everything you're telling me is why we're here today. Okay, this isn't a pretrial motion that I make a decision on. I make a final decision as to, what should happen in the case before me. And so what you're presenting is what you're going to be presenting during the case. It's not something I rule on ahead of time.
Okay.
Does that make sense?
Yeah, didn't you say that you ruled against it at the moment, but later on information might...
I ruled against. You made a motion for requesting the court appoint a new court visitor.
For our
I
personal
denied
representatives. That was what it was. We have to pay for it. That was what we're in reference to.
I don't know what that means, but
Can I explain?
Can I explain?
Okay, yes you can, sir. Sorry.
Okay. All right, thank you. The motion to appoint a new court visitor we addressed last time. I denied that motion. You have the ability, we discussed this last time and again today, and I think you understand, you have the ability to present your case with respect to why you think the court should discredit the court visitor's report and her work. And that's what you've been doing, and we'll continue the cross-examination today. The personal representative, again, that's not relevant to this case because your dad is still alive. So, are there any other pretrial motions that we need to deal with, Mr. Willie?
I'm having a hard time understanding this particular part about the court visitor. When we were sent her name as the personal representative who filed this petition, paid the $800 fee, she was the first one that came to us as this is what the probate court is saying, you need Mrs. Garment. We're looking at her first report and we're like, we don't want this lady's opinion. She never interviewed me, etc. In the second report, she heard everything bad about me, made statements, and in her second report, over a 4-month period, she had another opportunity to call any of us. She still didn't call me.
Okay.
So my
those are all things, Mr. Willie, that you argued during your case today. Court visitors get, maybe this is the part that is helpful. In a case like this, a court visitor is appointed by the court as a matter of routine. That's just what happens in all of these cases. It's not unique to this case. Ms. Salisbury, is this correct?
Yes, Your Honor.
So she was appointed.
She was appointed.
To me. She was appointed by the court
for me. No, she was
me.
appointed by the court to review this case.
No, she was reported
Mr. Willie, I'm not arguing with you about this. I'm telling you what her job is. She's not appointed to represent you or to help you. She's appointed to provide recommendations to the court regarding the issues at hand in this case. I understand you disagree with how she did her job. You think she didn't do it right. And that's part of your case, and that's the argument you're making to me to make a final decision. So that issue is settled. Do you have any other pretrial motions that are not tied to what we've just talked about?
Yeah, for the record, what you said to me was incorrect.
Okay. Any other pretrial motions? Mr. Willie?
No.
Any other pretrial motions from any party?
All right, if we could, in the status report, Mr. Walid mentioned his claim, and he's mentioned it again today. I think since we're here, it's a great time if we can indulge the court for a few minutes to discuss that claim that he's making as a person
If you could
representative.
direct me to the date and the motion we're talking about.
It was listed in the status report as filed on the 3rd of September.
Okay, let me pull that. The one filed at 4:41 p.m. on the September 3rd.
I believe so, Your Honor.
It says amended notice to interested persons, etc. Is that what you're referring to?
Let's see. You know, I did not print that one.
I have it right here, Your Honor. It was really September the 3rd.
What's the title of it?
The title is Amended Notice to Interested Persons, ORS 115-105, Claims Against Incapacitated Persons Estate
Okay,
or Deceased
that's
Persons
the one I
Estate.
have up on that screen. I don't know if that's what you're referring to, Ms. Salisbury. Is that what you're referring to?
Yes, that's the one we're referring to.
All right, we're all in the same ballpark. All right, go ahead.
So, in order to kind of save some court time from coming back for arguing this one, again, Mr. Martin Sr. is still alive, therefore a claim filed under any of the statutes that are ORS 115 is inappropriate. That's a probate statute that you use when someone's passed away and you're filing a claim against the estate, and there's a whole statute claim or preference of order and how you pay claims that come in and what the procedure is. But that is specifically for a probate. We're not in probate. We're in Chapter 125, ORS 125, which does not have a claims statute in there. The way it works is that if you have a claim against somebody, you just like you would any other living person, you would file a lawsuit against them, serve them appropriately, have an opportunity for them to file a response to that, and then go and actually present your case in front of a judge and get a judgment, and that judgment would go to the conservatorship estate to be paid or not paid or however that's going to work. So in order to save some judicial time, I figured it's here, we're objecting to it, and if the court wants to take that up as a pretrial motion to avoid us having to come back on this in the next month or so, that would be, I think, a good use of judicial time.
Okay, just 1 second. Okay, Mr. Waleed, with respect to that motion, it's entitled Amended Notice to Interested Persons, ORS 115-105, Claim Against Incapacitated Persons Estate. Your
Yes, I'm gonna.
argument on that motion.
Okay, I have something to add to that. Thank you. It's under priority of claims. We'd like to make mention, yes, that is correct about a judgment, and we have filed a case against my father in federal court, which will be served upon the other parties the next few days.
So, sorry, you
Yeah.
you filed a case against
Well,
your
what-
dad, Mr.
it's called- yeah.
I just want to make sure I understand what you're telling me,
Yes.
because it helps me to help. You have filed or plan to file a case against your dad, Gregory Martin Sr., claiming that, in simplified terms, he owes you money.
Correct.
Okay, go ahead.
We're speaking to the rules, Ms. Salisbury, about in this Oregon State Bar about estates, it's a seminar, but it talks about priority of claim, and it's like regardless of priority, a secured creditor whose lien attaches before the death of the descendant can claim the secured party on a first-time, first-in-right basis. Interpreting this as far as incapacitated and being deceased. My father is not deceased. However, he's being treated like he is. And there are certain petitions that were filed that don't even mention certain things regarding being incapacitated versus deceased. We know the difference between the two. So our approach to filing any particular motions was just to cover our bases. You know, if the court doesn't grant that, we're in another jurisdiction in the federal court. It's already been filed and is waiting for a summons to be issued that will resolve this particular issue. And it's on an account stated. That's where we are. We have an account with my father. He knows about it. He was aware of it. He just was interfered by several various different parties, and he caught dementia in the process, and he can't remember, and that's just the way it is. So if that's not an issue with the court, we filed it really to cover our bases based on our interpretation of the law, etc. But we have another jurisdiction where we will battle that issue out.
All right, Mr. Riddle.
Thank you, Your Honor. I agree that Chapter 115 is not applicable because Mr. Martin Sr. is still alive. Under Chapter 125, there's claims provisions in there as well, and under 125.510, a claimant has every right to file a separate action, which it appears that's what Mr. Wally has done, so his motion is moot.
Okay, thank you, Brian. Thank you, Mr. Willie. I think, Mr. Willie, you're on the same page as what I'm hearing from the other side, which is you wanted to let the court know, hey, I'm suing my dad because he owes me some money, but I'm dealing with that in some other case in some other venue. Am I saying that right, Mr. Willie?
Yes, that's correct.
Okay, so there's no decision for this court to make with respect to this. This was just a courtesy, if you will, to let me know.
Yes, that's correct.
All right, thank you,
Thank you.
Mr. Willie. All right, any other matters before we start the trial?
No.
From your perspective, Mr. Willie, we've addressed all of your pretrial motions.
Yes, you have. Thank
All
you.
right, and Ms. Wilkes, go ahead.
Thank you, Your Honor. It's unclear to me how I should address the court with this matter. I just obeyed at the previous trial and did as I was told, but no one ever asked me if I had counsel or was hiring counsel. So, and then when I was told I could ask the witness questions, I did so. But I am in the process of getting counsel. The one that had told me they would represent the case had to leave town on an emergency, and I found out late last night that they would not be able to represent the case. And also, I have no intentions of wanting to be past or present PO. So I don't know how I should address this to the court, but I don't want to be in the dispute of if I want to remain PO or someone else's PO or etc. And the other thing is I have underlying medical conditions that does not allow me to set for long periods of time. And when I sat through the previous trial, I was flared up all weekend and could not walk. I got some movement back by getting treatment yesterday, but I would like for that to be noticed. And I also have other medical conditions that allow me to frequent the restrooms. So
with respect to the medical conditions, just let me know when you need a break for the restroom or a break for other reasons. Okay. And your middle issue that you raised to the court was, am I understanding you correctly? You don't object to Ms. Fuller being appointed the fiduciary in this case?
I object.
Okay, then that's why you're here.
Okay, on the basis of what?
Okay, all right. So then you're a party to this case. I think what you're telling me is you object to Ms. Fuller being appointed the indefinite guardian in this case, but you don't want to be the
No,
guardian.
sir.
Okay, fine. I know that I've said that a few times, and so that may be the confusion. And so thank you for clarifying.
Thank you.
But because you have filed an objection, objecting to Ms. Fuller, you're a party to this case. You don't have to be a party to this case. If you're telling the court, I don't want to be a party to this case anymore, I want to leave, you're free to do that. But if you object to Ms. Fuller and you want to be heard, then you need to be here. on your first issue you raised, which I'll take to be a motion to continue the case to hire counsel, that motion is denied. This case has been pending since April. You've had plenty of time to secure counsel, and you haven't. So we have to proceed.
Your Honor, the reason being is there were numerous attorney's office that I had contacted that was going to handle the case. When I went to get funds, there was been an illegal lease pending put on my real estate, in addition to them shutting down bank accounts. So they made it impossible for me to have finances to hire an attorney. So it's been a process. And we mentioned it previous hearing. You said if we presented a motion to the court that you would consider the lease pendings, because there's no relevant reason why those lease pendings are on my real estate.
Okay. So
And the other reason being, I finally found one that want to accept it on pro bono, but they need time to withdraw all the documents.
Sure.
Yeah.
Thank you, Ms. Wilkes.
Thank you.
You've made your record on that issue, and your motion to continue the case to secure counsel is denied. And I refer back to the reasoning I gave prior. All right. Any other pretrial matters?
Just one, Your Honor. It sounds like maybe we might be able to have all parties stipulate regarding the incapacity of Mr. Martin. Obviously, in the claim filed by Mr. Waleed, he's stating he's incapacitated. So I'm wondering if we might be able to kind of take that issue off the table, if everybody would be willing to stipulate.
Mr. Rudolph. They're proposing a stipulation as to one of the elements.
Right, Your Honor. I would stipulate that Mr. Martin Sr. meets the definition of incapacitated under 125005.
Okay. Mr. Willie, what they're proposing is that they're asking whether or not you agree, and Ms. Wilkes, you agree, that your dad is incapacitated as defined under the law for purposes of this hearing. That way we don't have to deal with that issue anymore. Rather, we can focus on the other elements involved in this case. You don't have to agree, and it matters not to me, but that's what they're proposing. So your position.
I object. I was busy.
Okay, then that motion is denied. Anything else?
No, Your Honor.
All right, we can call Ms.
I'm so sorry, Your Honor. Is the court willing to allow me to eat during the hearing?
Oh, yes, yes.
Thank you. And then, apologies, Your Honor, there are strong scents in the courtroom. There might be a need due to my pregnancy, just so it's on the record, that I'm not getting any special treatment, that I might need to step out to get some fresh air.
Sure.
Is the court going to be okay with?
Of course, absolutely.
Thank you. Really appreciate it.
Yes, absolutely. Okay, let's get Ms. Garvin back on the stand. Thank you, Ms. Ellsbury. Since it's a new day, Ms. Garvin, we will go ahead and have you sworn in.
Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please be seated. And for the record, please say your name and spell it.
Catherine Garman, Catherine Garman.
All right, Mr. Waleed, I understand that we left off last time you were cross-examining Ms. Garvin. Is that correct?
Yes, sir.
All right, go ahead.
Good morning, Ms. Garvin.
Good morning.
Thank you for being here, and thank you for taking the time to see my father when it was appropriate for you to do so. I'm going to ask some questions today that might ring a bell or jog your memory a little bit, and of some concerns to your first report that was submitted to the court on
April 22nd, look, April 22nd, 2024. And I'd like to bring up the number 13th person on the list, which would be my sister, Alzina Martin. You stated that you spoke with Mrs. Martin. Can you give us, in the court today, a brief description of the conversation, or can you describe the demeanor of my eldest sister, Alzina, concerning her father, Gregory Sr.?
The gist of it I've contained in my report, and she talked to me about how she had helped her father access medical care, and she just spoke a little bit about what her dad's health was, and then how she pulled her sister Dawn in to help. She was concerned about her father and wanted her father to get the care he needed.
Did my sister mention me, Gray Jr., at all in the conversation?
I can't recall.
Okay. Did you also speak with Don Martin?
Not prior to this report.
Okay. Is there a reason why you only spoke with Alzina Martin out of 7 siblings?
I worked with the phone numbers I had, and with the temporary, you're under a relatively short period of time to get a report out.
So you're stating for the record that you only had one phone number out of 9 children, that you only contacted one?
No, that's not what I said.
Can you reiterate what you were saying?
I said I worked with phone numbers that I had. I made some phone calls. I can't recall who all I called, but I was able to reach your sister that I reference in the report.
Okay. Speaking of your references in the report, you stated that Rasta K. Waleed would not or could not have stopped the financial pillaging of my father's estate. I'm using those words on my own words, but you did mention that Rasta K. Waleed could not, would not. Can you reference that or read that part of the report to the court?
That was in the second report on the second page. And what I said was that you claimed that you were named power of attorney and that you were unable to prevent the financial exploitation or abuse that you alleged occurred.
Can I ask, when you say I was unable, as if you had knowledge of the facts, what do you mean?
I mean that there seems to be a consensus from Adult Protective Services, from your filings, from concerns raised by other parties, that financial exploitation occurred.
Okay.
That's it.
Go ahead.
No, that's it.
Okay.
This occurred.
Making that statement, would you, ever only having one person to call, do you think that that might have been a good time to call me to verify what I said or what was said about me, or are you relying on third parties' information instead of doing your own due diligence and calling to verify what you made in that statement?
No, this is the second report was based on filings with the court primarily. So the filings with the court, especially your filings, you allege that a lot of abuse, exploitation, things like that, you allege that in your report, in your filings. And so I was just commenting that you state that you were this power of attorney and this abuse or exploitation happened. That's all.
If those statements are not correct, do you have any research to stand on to verify that?
You mean if your statements are not correct?
Did I give you that statement?
No, your statements in the petition, in your petitions, you have alleged that there was exploitation and abuse. That's all I'm saying.
Okay, I'm saying you had one report where you did not contact me. Out of 9 children, you only spoke to 1. You had another 4 months. You were able to see numerous filings relating to maybe my disposition with the case, maybe my unhappiness, etc. Did you at any time, knowing that you missed me the first time in the first report, now you're going by maybe hearsay, because this is not my words, do you think it would have been beneficial to reach out and contact me as a court visitor to verify anything that I've said?
I think I'm confused. Are you asking me if I should have contacted you to verify what you put in filings with the court?
No, I'm asking you, why didn't you contact me?
I didn't contact you because you seem to be quite prolific on your filings with the court and making your voice heard.
Is anything that I've said that you reported conflict of interest or anything like that? You're repeating statements that someone else said or you picked up from my filings. You're the court visitor. It's your job, maybe according to the rules, you could have reached out and contacted me. Do you think you could have?
Do I think I could have?
Well, did you think you should have?
I felt that your prolific filings spoke for themselves.
And when you say prolific filings, are you talking about statements that were made by me concerning my father's disposition and me reporting it to Adult Protective Services? Were you aware of me reporting this to Adult Protective Services?
I don't recall. Again, lots and lots of filings.
Okay, and I think you're, thank you. Second question, did Megan Huffman reach out to you anytime during this process or your research to tell you about Rasta K. Waleed? Did she reach out and talk to you at all about my disposition or me reporting anything at all? Did you ever know that?
I'm trying to understand your question. Could you restate?
Yes, I can. Did you read the intake report?
I do not have access to APS reports. Those are confidential.
Okay. And did you speak with Megan Huffman at any time during your report?
I spoke with Megan, the APS investigator, prior to completing my initial report, I believe.
And did she ever mention Rasta K. Waleed reporting the abuse of his father on December 13th, 2023?
What I recall is that this was a very convoluted case that she was working. I did not specifically talk to her about who all she spoke to. I focused on the allegations. As I recall, there were allegations made against family members, and then there were allegations made against Ms. Wilkes and, I'm sorry, the power of attorney. I have to reference here. Mr. Wisdom. And in speaking to Adult Protective Services, when I do my investigation, I tend to get more sort of general, did you have findings? And the findings were unsubstantiated against family members, and they were substantiated against Ms. Wilkes. So that was the broad outline of my talk with APS.
So your statement about the claims of Mr. Rasta Waleed, claiming assets, creating conflicts of interest, where did that information come from?
Your filings.
I didn't say anything that there was a conflict of interest, did I?
No, your filings, there's been multiple filings where you're making claims of millions of dollars against your father. Your father right now is on Medicaid, and there's just an inherent conflict of interest when the focus of a person is on the finances and gaining finances back. So I considered that in my opinion,
You,
to be a conflict of interest.
okay, your interpretation.
That is my interpretation.
Thank you. Okay. Did you know of my father's business savvy or business acumen of what type of work he's involved in?
Very limited. The petition and my investigation is really focused on where your father is right now in terms of his physical needs and his care needs. So, looking back, that was, I have a limited knowledge, but I do not have intimate knowledge of his business practices, what he did. I know what his care needs are now. And that's the focus of this petition, is trying to meet his care needs now.
And did you know that Oregon Advocates LLC was not in business when they filed this emergency petition? Do you know the seriousness of that?
I don't have knowledge of what you're speaking of.
So, in your report to the court, when you're dealing with businesses, do you check to see if the businesses are even legitimate businesses?
I check to see if a professional guardian is nationally certified.
What about the business that represents them?
That's typically not the role of the court visitor.
Of your court visitorship requirements?
I would say any court visitor would not be looking at business licenses, things like that, on a professional fiduciary.
If you're looking at a professional fiduciary license, wouldn't you say they go hand in hand?
I'm looking at a disclosure statement. I am looking at if they're certified.
Okay, I understand there might be something you didn't look or maybe not be a part of your practice. However, has the name Oregon Advocates LLC ever crossed your radar in any report?
Oregon Advocates is a professional fiduciary. I have had cases before where they have been appointed.
Okay, so you're familiar with Oregon Advocates LLC.
Yes.
Or have you ever owned a business in the state of Oregon or anywhere at any time?
No.
Okay. Are you familiar with the Secretary of State and what the role of the Secretary of State is for any corporation, LLC?
It's not something that I have direct knowledge of, no.
Would you like to know?
Objection, that is not a
Sustained.
question.
Are you aware that the Oregon LLC on April the 18th, between that time and April the 28th, for 8 months prior to this particular petition, that they were revoked for failure to file their annual report and were out of business when they filed this petition?
I do not have this knowledge.
You do now.
Objection.
Sustained.
Where is the county of Columbia?
North of Portland.
Is this particular case in Multnomah County or Columbia County?
It is in Multnomah County.
I'm referencing your report that has Columbia County on here, signed by you that this is in Columbia County.
Correct.
But you're saying we're in Multnomah County.
Correct.
Is this an error on your report?
No, that's part of an interesting discussion that occurred. I've been a court visitor. I'm starting my 29th year, and I always, on my reports, put in the county of where the report was to be filed. And it was pointed out to me about several years ago while I was in a Clackamas County hearing, before the hearing had started, that why are you signing this saying you are in Clackamas County, because you're actually signing it at your office in Columbia County. And we had sort of a off-the-cuff discussion with the judge in Clackamas County, And the judge says, no, that's correct. You should be putting the county where you're signing the document. So I dutifully changed that so that no matter what county I file in throughout the state, when I sign that I am writing this report from Columbia County.
Okay. Okay. Are you required to have your reports notarized in front of a notary?
When we started when I started in '96, yes. And then it changed, they changed the wording. They changed the wording of the reports and how it's filed over the years. I do not know when it was changed to this format. We do not need it notarized.
Okay. Are you referencing Mr. Doyle? I would like to ask a few questions about Mr. Doyle. Have you spoke with Mr. Doyle or called him about this particular report for any matter?
I've never spoken to Mr. Doyle. I've heard Mr. Doyle's voice on the phone during some short matters. Other than that, I have had no contact with Mr. Doyle.
Okay. Is there a reason why you haven't had any contact with Mr. Doyle?
There was no reason to.
Have you had any contact with Mr. Nathan Rudolph?
Briefly, we were meeting together. We met together to see the respondent.
My question is, Mr. Doyle in April was the attorney for my father. Why wasn't there any effort to meet with him concerning any issue about my father, like you gave to Mr. Rudolph?
By the time I filed this report, that's when all the objections and everything came through. I did not even speak to Mr. Rudolph until he had been appointed by the court. And I guess the way I would describe it is the dust had settled a bit. I can't remember who contacted who, but we met up at the hospital. And it was just by chance that was when I had scheduled my meeting and he had scheduled his meeting.
So by chance, in front of the court, you're saying you cannot state for the record who contacted who? I mean, it's a vital issue of the next question that I'm going to ask you.
I can't recall.
Can we give you a moment to think about it?
Mr. Relici answered your question. You can ask your next question, okay?
Okay. So, Mr. Doyle, did he ever contact you at all?
No.
Did you ever contact Earl Wisdom?
No.
Is there a reason why?
Again, I go back to the genesis of the petition. The petition was filed because of concerns raised by the ethics committee at the VA hospital and by findings of the Adult Protective Services. And they asked for a professional guardian because the power of attorney, the healthcare representatives, were non-responsive. These are the reports I'm getting from the hospital. And Adult Protective Services had substantiated exploitation. My general practice is that if financial exploitation, for instance, has been substantiated, and in cases like this, there's been a referral to law enforcement, I do not contact these people because I don't want to accidentally get in the middle of a criminal investigation and muck things up.
Okay. And this goes back to, you didn't contact Mrs. Selena Wilkes either?
That is correct. For that reason, and interestingly enough, in the last hearing, she noted that she didn't even have a phone, so I would not have been able to call her anyway.
And you knew that Earl and Selena both were power of attorneys over Mr. Gregory Martin Sr.
Correct, and Adult Protective Services had substantiated this exploitation, and I do not, as a rule, call when there's been substantiation.
Now, you've read numerous motions, exhibits, pleadings, and it mentions Mr. Roster K. Waleed, and you mentioned that I was, or you had knowledge of me being his power of attorney before you wrote your report. Was Mr. Waleed substantiated to have any abuse against his father from the Adult Protective Services?
I don't believe in the first report I had not heard anything about you being power of attorney. That only came up after you started your filings.
My question then, thank you for being clear with your answer. Then why wouldn't, in your investigation on your secondary report, wouldn't you reach out to find out what was the story behind Mr. Roster K. Waleed and his durable power of attorney? Why didn't you reach out, knowing that everyone else was supposedly found guilty or substantiated to have harmed my father financially or physically? So you didn't contact them, but you hear that there's a third person, his son, and you didn't reach out to verify any of his durable power of attorney status, or weren't you curious at all?
Again, I go back to, you were very prolific in filing documents with the court. And in the documents, you talked about these power of attorneys. You talked about abuse, neglect, and things like that. And the concern was, if indeed you had the power of attorney, you were unable to effectively use it to prevent all of this abuse and neglect you say occurred.
Is that your opinion, or is that what any of the pleadings were mentioning? Where are you coming up with this statement?
I'm coming up from your statements where you make a lot of allegations about abuse and neglect that happened, that you reported to APS and things like that, while at the same time saying that you had that you had this power of attorney, which there was no explanation that I could see in those documents where you utilize that power of attorney to intervene on behalf of your father. Instead, there's more documents being filed where you are instead asking for millions of dollars from your father's estate. And again, your father at this time is on Medicaid.
Thank you for your answer, but my question would be, as a court visitor, if there's any doubt or there's some questions that were not raised in your first report, why didn't you report that or contact to find the answers, to substantiate the report?
Because I go back to, I felt like you were prolific in filing your explanation of that. Your voice was heard.
So that's all the requirements of your job as a court reporter? Visitor.
Could you restate that question? I don't understand your question.
Okay. Let me switch the question so we don't get any objections here. I'm talking about ORS 125.165 and its qualifications and standards for visitors. And number 2, it talks about what a visitor may not have any personal relationship in the respondent or protected person, any financial interest in the proceedings, and if those interests could compromise or affect the decisions of the visitor. I'm just trying to state with those particular rules why did not Mr. Waleed get an investigation on your behalf? That's just a simple answer.
I don't understand the connection there. Well, I
Are
don't
we
understand what
having
you're asking.
cognitive dissonance about the question?
Your Honor, objection.
Assistant. So I think the question that I think you're trying to ask, and I think you've made your point
Okay.
here, but I think what you're trying to ask is, how come she didn't call you? Right? Am I saying that right, Mr. Williams?
That's the basis of it when,
Okay, and I think her answer
Okay.
a number of times has been she felt that your voice has been
Okay.
heard through the prolific filings.
Okay.
That's
Okay.
why she didn't call you.
okay. We're gonna ask some other questions that directly relate to the investigation done by the panel and the committee on Mrs. Fuller. And we heard you say some things under oath, and we want to bring these things to the attention. And there we go. Just give me a moment. Are you familiar with the May 14th, 2024 Oregon Judicial Department Conservatorship Auditing Program, or the Office of Internal Audit Consultation Report for case number 24PR00777 and regarding Holly Ryman?
Is that the CAPS review that was referenced in the Clackamas County case?
Specifically, this is a proceeding that took place January the 4th, 2024. You mentioned that this report is if you had read this report, and you mentioned several things, so let me bring specifically here to you on page number, is it 9? Okay, yeah, here. And did you get this report at all? I mean, you mentioned it, I believe, in your testimony on August the 27th. And this is a numerous report that was talking about several things regarding Mrs. Fuller's guardian reports. And it was about the circumstances of Mrs. Fuller not informing the court of particular and regarding Trey Main, case number 5104-08649 on June the 13th, 2019. It was regarding the removal from the Morningstar case.
I'm going to object, Your Honor. Frankly, I don't understand what the question is.
Really?
I'll bring it back.
I don't think he's got to the question.
I'll bring it back. I'm referencing.
Yeah, I think
Okay.
there's a little lead up there, so we're
Okay.
just asking for the question, okay?
Yes, sir. The question is, the Oregon Judicial Department published a report, a consultation report on Mrs. Fuller. It was a full investigation concerning the guardianship practices and information left out of petitions, several of them, one being the Morningstar case. Do you remember the Morningstar case?
I don't have any personal knowledge of the Morningstar case.
Well, there was in the first report you mentioned, I'll find the page here, that there was a Morningstar case, and you mentioned that the judge did something different. Ms. Fuller indicated, okay, let me find this. You wrote in your report that Giselle Fuller on page 4 was removed as guardian in Lane County case 16 PR 00749 under Judge Holland, and signed the judgment and wrote after review. Can you recall what was stated in that report? Because you wrote it in your report to the court, your first report.
That would be on page 4 of my initial report. And if you're speaking to the Lane County case 16 PR 00749, there was the statement from Judge Holland, After review of all exhibits submitted by the parties based on witness testimony and based upon Oregon law, the court finds that the guardian has breached her duties regarding the general welfare of the respondent and has breached her financial duties to the respondent.
Then you continue about, of note, that Judge Holland continued to appoint Mrs. Fuller to serve as fiduciary after this date, and a guardian partner's monitor submitted the report in complex. Do you remember your statement? Can you read the last of that, page 4? It's important that this be brought up because there were questions that she mentioned under oath that didn't state this.
Your Honor, objection, testifying.
I'll give him some latitude. Go ahead.
What is the of note on page 4? Is that yours or is that something from Judge Holland?
That was my statement.
Can you repeat that statement so we're all on the same page?
Of note, Judge Holland continued to appoint Ms. Fuller to serve as fiduciary after this date. And a guardian partner's monitor submitted a report in a complex case where Ms. Fuller served as guardian with positive results.
Where did you find that information out? Was that your opinion or was that what Judge Holland had said?
That report came from Giselle in terms of being appointed afterwards. I don't have the case numbers. You'd have to speak with Ms. Fuller or her counsel about who and in what capacity. And the guardian partners monitor report, I was given the number. I don't recall what number it was. I reviewed it, and there were positive results in terms of how that case was being handled, that the guardian was doing a good job.
Why did you pick that particular case to talk about in your report?
So Guardian Partners is about 10 years old now, and they do one of two things. They either do random monitoring of cases, typically older cases, or they can be appointed at any time by the court as to monitor a case. So if there's concerns about a case, for instance, if a report has not been filed in a timely manner, or if there is a letter to the court expressing concerns about a case, the court can appoint guardian partners to monitor a case. I cannot recall why this case was monitored. I don't know. All I saw was the report. And guardian partners, they do a very comprehensive report where they look at the conditions the respondent is, or by that time protected person, is living in, if there's any concerns about the quality of care, the residents, and they also give their recommendations and understanding of what they feel is the guardian's job, if they're fulfilling their duties as a guardian.
Okay. This goes back that are you picking and choosing what you want to say? I'm asking this in this consultation report. It mentions several cases that were not a part of your report, that the central agency for guardianship and business, I just want to know if you have seen this report, because this report is important. It talks about the history of the agency. Do you have a copy of this
testifying
report?
again as well, Your Honor.
yeah.
We're not getting a question.
Okay.
We're getting compound, complex testimony and questions in one.
I'm
Just confusing the
straightforward, Your Honor.
witness.
Thank you, so Mr. Willie, just I'll give you some latitude because you're not an attorney, and cross-examination is hard even for attorneys. So it is helpful if you do your best to ask kind of more simplified questions, if you will.
Okay. That makes sense.
Too much lead in, I think it's confusing, and then if you testify, you're going to get to testify, by the way. So go ahead.
Okay. There was a report, consultation report, on several cases from the Oregon Judicial Department. One being, in the case of Tremaine, case number 51404, are you familiar with Mrs. Fuller being appointed guardian in this case? And anything about that case? Are you familiar with, in regarding Tremaine? It's a case that looks like it was after the removal of the Morningstar case.
I don't know these cases by name or number without seeing something. Just off the top of my head, no. I don't know these cases intimately.
Okay. Could we say that it's the purpose of your report to report an unbiased report to the court regarding Mrs. Fuller's guardianship experience?
That's the goal of the court visitor, is to be the independent sort of eyes and ears for the court.
Okay. So I'm trying to reiterate this right. Are you familiar with the auditing program and the consultation report filed in January 4th of 2024?
I saw the CAPS report. If it's the one that was also, I believe, filed with the court by DRO, by Disability Rights Oregon, when they filed their, and I'm going to mess up the term, amicus curiae.
You did right. That's good.
It's Kira.
Okay, yeah, they filed a letter, and I believe they attached 2 documents. They attached Judge Norby's letter, and they attached the CAPS review.
And are you stating for the record that you read that review?
I saw the review.
Okay. So let me simplify this. Regarding the Tremaine case, was Mrs. Fuller, after the Morningstar case, was Mrs. Fuller cited for not reporting her being kicked off that case?
Your Honor, objection. She already testified that she does not remember that case. To ask her about it, she's already answered. She does not remember that case, and she can't have a recollection reflected on that case.
Overrule, you can answer the question. But if the answer she doesn't remember, then she doesn't remember. But go ahead.
Well, may I approach
So,
this
Mr.
bench?
Lee,
May I give her this report? Because she said, she mentioned it. Maybe she does. It's a lot.
Mr. Lee, so you asked a question, so I'm just going to have her answer that question first,
Okay.
and then you can do what you want next. Okay, you can answer that question.
Okay.
Ms. Garman.
Could you restate?
Yes. It says the court, the protected person, Ms. Fuller's removal. Are you familiar with her removal from that case, from not reporting to the court her disposition of being kicked off that case?
I guess I'm confused by your question.
Would you like to see this?
What I can say is, in my second report, I reflected the concerns about removals on different cases, or concerns by judges in different cases. And did I do a deep dive into all those cases? No, because that's not my duty as such, to go into those other cases. My responsibility is to this case. So I just reflected just sort of the general statements from those courts. But as far as the specifics of each case, no, I don't have those burned in my brain. I don't recall all the fine details of those cases.
Okay. Also, in the case of regarding Adams, in the same report, it was told that Mrs. Fuller, again, was cited for not notifying the court that she was removed from this particular case.
Again, objection, Your Honor. Testifying There's no question.
Oh, I'll rephrase the question.
Okay, go ahead and rephrase it.
In the consultation report, do you remember in the case regarding Adams, any citation about the first case?
Your Honor, objection. She's testified multiple times. She does not remember the specific cases.
I'm just stating that Mr. Willie, she doesn't recall the details. The point you're trying to make to the court is that I think you've made it well, which is she didn't do a deep dive into the cases that she mentions in her report. And the court should consider that in determining whether Ms. Fuller is a suitable guardian. So I think that point is well made. As soon as you've seen an objection, you can ask the next question.
In this consultation report, when you didn't take a deep dive, are you familiar that there are 11 individual cases that state the same thing regarding Mrs. Fuller's non-reporting to the court?
No.
According to ORS 125165, this is the state law again, and it states in number 3, the qualifications. Do you feel you meet the qualifications of a court reporter, a court visitor?
I think more importantly, the courts believe I meet the qualifications.
What about yourself? Do you believe you meet the qualifications?
Yes. And I believe I've had the court's support again for going on 29 years.
Do you consider yourself an expert in this field?
Expert's a heavy word. I believe I continue to, and I want to continue to learn on the job and do the best I can.
Excellent answer. I have no other questions.
Thank you, Mr. Lee. Ms. Wilkes, any questions?
Yes.
Go ahead.
Good morning.
Good morning.
Did you contact Earl Wisdom at any time?
No, I did not.
Is there a reason why?
Again,
Objection. Asked and answered.
Also stated, yes, Ms. Wilkes, she did answer that question earlier.
Did you make an attempt to contact Selena Wilkes?
Objection. Asked and answered.
Also stated that is true, that question was asked earlier as well.
Were you aware that there were working phone numbers at the time of your first and second visitor's report?
for who?
Both parties, Mr. Wisdom, Mrs. Wilkes.
I did not have that information.
Did you mention earlier that there wasn't working numbers?
No, what I referenced earlier was why I didn't call, and then of note, at the end of the hearing, you commented to the court that you did not have a phone and that the phone you had was borrowed. That's all I was referencing.
Were you aware that that was just for that court notification at the end of the hearing?
No, I was just noting what was stated then.
You mentioned, were you aware of the allegations in Megan Hoffman's reports?
I'm not sure who or what you're speaking of.
Megan Hoffman was the investigator?
Oh, Megan, Adult Protective Services?
Yes.
Could you restate the question?
Were you aware of allegations in Megan Hoffman's reports?
My understanding, there were two separate investigations. Which investigation are you speaking of?
Both.
So I can't recall exactly the allegations. I know there were allegations against family members. They were unsubstantiated. There were allegations of financial exploitation against you, and Adult Protective Services substantiated those concerns and I believe made a referral to law enforcement.
Were you aware that they were allegations? Did you see any evidence of supporting that?
No, I just have the report from the investigator saying that there were allegations and referred to law enforcement. And again, law enforcement would do a separate investigation from there.
Are you aware the responsibilities of a court reporter when allegations or individuals are involved?
I don't believe I understand your question.
What are your responsibilities as a court reporter in reference to notifying every individual that's involved?
The court visitor does not have any obligation to notify individuals about the petition. That's not in the court visitor's purview. That's not what we do.
Was that why you made no attempt to interview Earl Wisdom or Selena Wilkes?
Objection asked and answered.
Overruled. You can answer.
Could you restate?
Based on the statement that you just made, was that the reason why you made no attempts to notify Earl Wisdom or Selena Wilkes and get their reports?
No. Again, it came back to concerns raised by the VA, concerns raised by Adult Protective Services, and focusing on sort of that going forward to get Mr. Martin protection.
Did you ever meet with anyone on the ethics committee at the VA?
No, I did not.
Did you ever see a report from the ethics committee at the VA?
I reviewed, I believe, a consultation from the ethics committee at the VA.
Do you recall who submitted that report?
That would have been in my first report, and I think it was Dr. Molly Osborne, MD, PhD. She's a physician, and she did the ethics committee consult for the VA, and that was on, April 3rd, 2024.
Was there anywhere in the report where they attempted to make contacts with Mr. Wisdom or Mrs. Wilkes?
I do not right now recall the specifics of the report.
Was that report filed with the court?
Because of HIPAA, I do not file any medical reports with the court. That is not standard practice.
Ms. Wilkes, I'm gonna have you pause. Now's a good time for our morning break. It's 10:30.
Thank
We'll
you.
be in recess until 10:45. We'll resume cross-examination at that time. Thank you.